Now we turn to one of the checks and balances, which is not talked about in classes, the oath of office. Every elected federal official takes one before taking office. This next video will remind us exactly how the founders viewed a personal oath. Few history books in school teach us what happened to many of those founders after the War of Independence as a result of taking an oath. Today, our representatives treat the oath as a mere formality, not as a mark of personal integrity. Now you will hear the rest of the story.
Americans, the how and the why of our beloved republic are so much better known and understood than the who. The United States of America was born in 1776, but it was conceived 169 years before that. The earliest settlers had watered the New World with much sweat. They had built substantial holdings for themselves, for their families. And when the time came to separate themselves from a tyranny an ocean away, at best it meant starting all over again after the ravages of war. Researching what you're about to hear gave a whole new dimension to my reverence for our nation's first citizens. All others of the world's revolutions, before and since, were initiated by men who had nothing to lose. Nothing to lose. Our founders had everything to lose and nothing to gain, except one thing. Hello, Americans. I'm Paul Harvey. You remember the cherry tree fiction a long time after you have forgotten the more earth-shaking history-making episodes in the life of George Washington. You have misplaced in your memory the details of Ben Franklin's statesmanship, but you remember his flying a kite. Joyce Kilmer was a great military hero, but the only thing you personally recall about him is his poetic tribute to trees. Maybe of this current decade, that which will be remembered best will not be its wars and its moon rockets or its crumbling frontiers or the giants who lived and died. Maybe all that'll survive to linger in the day-by-day vocabulary of generations yet unborn may be the songs of a Memphis minstrel or the reincarnation of electric automobiles. But for any eve of the 4th of July, I, Paul Harvey, do herewith bequeath unto you something to remember. You may not be able to quote one line from the Declaration of Independence at this moment. Henceforth, you'll always be able to quote at least one line. It's in the last paragraph where you will recall when I remind you. It says, "We mutually pledge to each other our lives, our fortunes, and our sacred honor." In the Pennsylvania State House that's now called Independence Hall in Philadelphia, the best men from each of the colonies sat down together. This was a very fortunate hour in our nation's history, one of those rare occasions in the lives of men when we had greatness to spare. These were men of means, well-educated. 24 were lawyers and jurists. 9 were farmers, owners of large plantations. On June 11, a committee sat down to draw up a Declaration of Independence. We were going to tell the British fatherland no more rule by redcoats. Below the dam of ruthless foreign rule, the stream of freedom was running shallow and muddy, and we were going to light a fuse to dynamite that dam. This pact, as Burke later put it, was a partnership between the living and the dead and the yet unborn. There was no bigotry, there was no demagoguery in this group. All had shared hardships. Jefferson finished a draft of the document in 17 days. Congress adopted it in July, and so much is familiar history. But now, King George III had denounced all rebels in America as traitors. Punishment for treason was hanging. The names now so familiar to you from the several signatures on that Declaration of Independence, the names were kept secret for 6 months, for each knew the full meaning of that magnificent last paragraph in which his signature pledged his life, his fortune, and his sacred honor. 56 men placed their names beneath that pledge. 56 men knew when they signed that they were risking everything. They knew if they won this fight, the best they could expect would be years of hardship in a struggling nation. And if they lost, they'd face a hangman's rope. But they signed the pledge. And here is the documented fate of that gallant 56. Carter Braxton of Virginia, wealthy planter, trader, saw his ships swept from the seas. To pay his debts, he lost his home and all of his properties and died in rags. Thomas Lynch, Jr., who signed that pledge, was a third-generation rice grower, aristocrat, large plantation owner. After he signed, his health failed. His wife and he set out for France to regain his failing health. Their ship never got to France, was never heard from again. Thomas McKean of Delaware was so harassed by the enemy that he was forced to move his family 5 times in 5 months. He served in Congress without pay, his family in poverty and in hiding. Vandals looted the properties of Ellery and Clymer and Hall and Gwinnett and Walton and Hayward and Rutledge and Middleton. Thomas Nelson, Jr. of Virginia raised $2 million on his own signature to provision our allies, the French fleet. After the war, he personally paid back the loans, wiped out his entire estate, and he was never reimbursed by his government. In the final battle for Yorktown, he, Nelson, urged General Washington to fire on his, Nelson's, own home, which was occupied by Cornwallis. It was destroyed. Thomas Nelson, Jr. had pledged his life, his fortune, and his sacred honor. The Hessians seized the home of Francis Hopkinson of New Jersey. Francis Lewis had his home and everything destroyed, his wife imprisoned. She died within a few months. Richard Stockton, who signed that declaration, was captured, mistreated, his health broken to the extent that he died at 51. His estate was pillaged. Thomas Hayward, Jr. was captured when Charleston fell. John Hart was driven from his wife's bedside while she was dying. Their 13 children fled in all directions for their lives. His fields and grist mill were laid waste. For more than a year, he lived in forests and caves and returned home after the war to find his wife dead, his children gone, his properties gone, and he died a few weeks later of exhaustion and a broken heart. Lewis Morris saw his land destroyed, his family scattered. Philip Livingston died within a few months from the hardships of the war. John Hancock, history remembers best due to a quirk of fate rather than anything he stood for. That great sweeping signature attesting to his vanity towers over the others. One of the wealthiest men in New England. And yet he stood outside Boston one terrible night of the war. And he said, "Burn Boston, though it makes John Hancock a beggar, if the public good requires it." So he, too, lived up to the pledge. Of the 56, few were long to survive. 5 were captured by the British and tortured before they died. 12 had their homes from Rhode Island to Charleston sacked, looted, occupied by the enemy, or burned. 2 lost their sons in the Army. 1 had 2 sons captured. 9 of the 56 died in the war from its hardships or from its more merciful bullets. I don't know what impression you had of the men who met that summer in Philadelphia. But I think it's important that we remember this about them. They were not poor men. They were not wild-eyed pirates. These were men of means. They were rich men, most of them, and had enjoyed much ease and luxury in their personal living. Not hungry men, certainly not terrorists, not irresponsible malcontents, not fanatical incendiaries. These men were prosperous men, wealthy landowners. They were substantially secure in their prosperity. They had everything to lose. But they considered liberty, and this is as much as I shall say of it. They had learned that liberty is so much more important than security, that they pledged their lives, their fortunes, and their sacred honor. And they fulfilled their pledge. They paid the price, and freedom was born.
You see, to the founders, the oath was not simply a ritual. It reflected their personal moral duty. And keeping your God-given rights depends on honor and integrity of those you elect to office. There is no law, no amendment, no clause that will enforce the limits of the Constitution. Let's take an example where the oath is to be used as a check on the other two branches. Imagine you are President of the United States. Congress makes a law which says Jews must wear a yellow star on their arm and Christians must wear a white cross. You vetoed the bill, but Congress overrode the veto. A case on this is brought to a federal court and is upheld by those judges and claimed to be the law of the land. Are you, as president, going to enforce the law? Look at your oath of office. Does your oath require you to obey Congress unless and until a majority of Supreme Court judges say you do not have to? Here is what the oath is not. It is not a pledge to go along with Congress. It is not a pledge to submit to federal judges. It is not a pledge to go along with a political party's decisions. Nor is it a pledge to vote your conscience or to make voters happy. The oath pledges allegiance to abide by the limitations prescribed in the Constitution. That's all. Is this mentioned in any government classes in school? Now, back to the President and his dilemma to support the Constitution. It is the President's sworn duty to refuse to enforce any unconstitutional law made by Congress. Accordingly, the President will review the enumerated powers and will ask, where is Congress authorized to make a law which requires Christians and Jews to wear armbands? You will see there is no authorization for Congress to make the law. You will see the Supreme Court's unconstitutional opinion which upheld the law. You will denounce the law and the judge's opinions as mere usurpations, and you will instruct the Attorney General not to prosecute violations of that law. You will recall your study of the Federalist Papers that solidly backed up your opinion about whether or not that law was constitutional. For most of the last century up to today, law schools teach that the Constitution means whatever the Supreme Court says it means. Over 100 years ago, Charles Evan Hughes, who later became Chief Justice of the U.S. Supreme Court, said, "The Constitution is what the judges say it is. This is what is taught in law schools, and that is what most Americans have been led to believe." As a result, we have generations of lawyers and judges since FDR's time that believe that federal court decisions are the law of the land. But this is not the case and was never intended to be the case, as you have read in the founders' own words. Recall Elena Kagan's video and her reference that even your natural rights, in her view, are to be interpreted by the courts. Her belief, and those of many others, because that was what they were taught, is that the courts, not God, are the final arbiter of your rights. And you did not have to ask any professor, a pundit, or constitutional expert to get the answer. Now to the concept of enumerated powers. This is the heart of your study and backs everything else up. The concept itself is not hard to learn. It's just different. There are just two things to keep in mind when considering the concept of enumerated powers as it was intended. 1. The Constitution is a permission slip to let the federal government address a few specific subjects only. It's not a list of the many subjects the federal government can address. It's a list of the only subjects Congress may address and regulate for the country as a whole. Second, in that light, it's just as important to know that if the Constitution does not say the federal government can do something, then it cannot. For example, if the Constitution gives the legislative branch authority to create laws, as it does to Congress in Article 1, but does not give them the authority to delegate lawmaking authority to the executive or judicial branch, then they cannot make laws. So if that's the case, how can the EPA make environmental regulations? How can the Department of Labor make minimum wage laws? How can the Department of Transportation make laws to force airline passengers to be scanned at airports? How can the Department of Energy make regulations on where to drill for oil, or why not to drill at all? The answer is they cannot lawfully do it. They do it because they can get away with it. And they get away with it because the voting public does not understand the concept of enumerated powers as it was intended to be understood. The departments and agencies we just mentioned are not in the legislative branch at all, but are offices of the executive branch. Let's go back to the very first article, very first section, the very first clause, because it's very important. It says that only Congress can make laws, correct? But that's not what is happening today. There are over 130 departments and agencies in the executive branch which make laws and regulations unlawfully and unconstitutionally. Here is just a partial list of unconstitutional departments and agencies. Somewhere along the line, we, as a nation, have lost the whole concept of personal freedom as the founders understood it. And worse, some people do not care. They embrace the extra government services, even if it's at the expense of the exercise of some of their God-given rights. When in doubt about any federal action, we must always ask first, where in the Constitution is it? So, a good understanding of the concept of enumerated powers is necessary, and we now build on the foundational principle of God-given rights, which we stressed earlier. Protection of our God-given rights was always the end goal of our founders, and this was to be accomplished by limiting the number of subjects the federal government had the lawful, moral authority to address for the nation as a whole. All other subjects were left to the states or the people. Subjects like health, education, housing, labor, transportation, religion, abortion, tobacco, parks, alcohol, privacy, and so forth, all those subjects were left to the states or to the local level to regulate. By intentionally excluding those subjects, the Constitution prohibited the federal government from addressing these matters. The more subjects the federal government regulates, the more fractional bites will be taken out of the exercise of your God-given rights. Consider the dreadful 16th Amendment, whereby we gave the federal government permission to keep part of what we earn. Our natural God-given right is to keep all that we earn, not just part of it. The more limited the federal government, the closer we keep the exercise of our God-given rights in our own hands and out of the hands of legislators. As you can see, we are stressing, as the founders did, the enumerated powers in terms of the subjects they can address. That's crucial. The founders did not authorize a budget because the list of enumerated powers was the budget. The federal government only has the power to appropriate money on the subjects they can address. The concept is really simple. The concept of enumerated powers assures us that the Constitution cannot be out of date, as has been claimed, because any subject the federal government is prohibited from addressing, like space travel, social media, and so on, is left to the states or the people. All subjects are covered all the time. The question is, by whom? The federal government, the states, or the people? In the founders' view, the closer to the citizen, the better. And recall that it's just as important to know what the Constitution does not say as well as what it does say. We previously gave the example that the government only has the power to coin money, not to print money. Therefore, the paper money system we use today is completely unlawful and unconstitutional. The founders' use of the word coin as a verb illustrated their intent of not using printed money. If you want to know how they understood the word, the closest dictionary we have for that time frame is Webster's 1828 dictionary. There is an online version. Please feel free to look up words you are curious about, since word meanings change over time. For example, back then the word gay meant joyful and happy. Today that's not even close to its use. Let's now see what subjects the three branches of our government have permission to address. These are the enumerated powers we spoke about earlier. It's easier to remember them if we break them into four categories. 1. International issues, including war and trade. 2. Domestically, issues regarding a commercial system with uniform weights and measures, a money system based on gold and silver, patents and copyrights, bankruptcy laws, and so forth. Third category, a few civil and voting rights in the amendments. And fourth, immigration issues, which include establishing a uniform rule of naturalization of new citizens. So, again, the four main areas of authorized federal involvement are international issues, a commercial system, some civil and voting rights, and lastly, some immigration issues. Beyond those, all other subjects are left to the states or the people. These are easy to remember, as these are not issues that come up in our everyday life. For our part right now, let's deal with the enumerated powers of the legislative branch only. Keep in mind, this is just a general list. See how many of these apply to your daily life and compare to where we are today. Article 1, Section 8 enumerates to Congress these and only these powers: to lay certain taxes, to pay the lawfully incurred debts of the United States, to declare war and make rules of warfare, to raise and support armies and a navy, and to make rules governing the military forces, to call forth the militia for certain purposes, and to make rules governing the militia, to regulate commerce with foreign nations and among the states and with the Indian tribes, to establish uniform rules of naturalization, to establish uniform rules on bankruptcies, to coin money and regulate the value thereof, to fix the standard of weights and measures, to provide for the punishing of certain counterfeiting, to establish post offices and post roads, to issue patents and copyrights, to create courts inferior to the Supreme Court, to define and punish piracies and felonies committed on the high seas, and offenses against the laws of nations. By the way, the laws of nations is defined in Webster's 1828 dictionary. Other provisions of the Constitution, including amendments, grant Congress powers to make laws on a few other subjects. This is the federal government's list of subjects they may lawfully address for the nation as a whole. Notice that matters Congress may address are matters which do not come up in our everyday lives. There is no power listed to regulate the subject of transportation, but we have federal regulations on automobile airbags, seat belts, exhaust emissions, mileage requirements, braking systems, bumpers, and many more. Therefore, all these regulations are beyond the power that we granted to Congress by our founding documents. Please note, the question is not whether or not the regulations are good or useful, but whether Congress made the regulations with no proper authority to do so. If they can step out of their bounds to do this, what is the limit? If they can make laws on the subject of health care, for example, without proper, lawful, constitutional authority, can they not just as well make laws forbidding health care? Or who gets it and who does not? Where's the limit? The Constitution is the limit, and as long as it's in place, we have recourse. We will get to remedies in the latter segments of this course. The founders had some good remedies, but today's Congress and we the people have ignored them for a long time. Now, instead of addressing what Congress may not do, let's address their broader powers. There are two provisions in the Constitution which grant to Congress broad legislative powers, but only in specifically defined and relatively small geographic areas. Let's look at those. Article 1, Section 8, next to the last clause, grants to Congress the power to enact exclusive legislation over the following areas. The first one is the seat of the government of the United States, but that's not to exceed 10 square miles. In addition, they may exercise exclusive legislation over forts, arsenals, dockyards, and other needful buildings. Exclusive means that only the U.S. Congress may make laws over that particular geographical area, and that those laws may address all needful subjects. Of course, such laws must comply with the first 9 amendments and other protective provisions of our Constitution, such as Article 1, Section 9. The states have no authority here if it's exclusive to the federal government. Again, referring to the Federalist Papers as the authority to meanings, James Madison stated in Federalist No. 43 that it was necessary for the United States to have complete authority at the seat of the government and over forts, magazines, and so forth. Just a note here. Throughout this class there are frequent uses of the term "for the country as a whole," and we have used it here as well. The reason is because in the federal enclaves, noted in Article 1, Section 8, next to last clause, where they are given exclusive legislative authority, Congress can make whatever laws are needful. They are not limited to the enumerated powers. But for the country as a whole, they are restricted to the enumerated powers. In many cases, it's simply not correct to make a blanket statement about the restricted powers of the federal government without also acknowledging the exception. For example, we cannot make the blanket statement that Congress has no authority to address the subject of transportation, because at the seat of the government, the 10 square mile area mentioned, and for the docks, forts, arsenals, and so forth, they may make any needful laws as long as no other constitutional provision is violated. So, for example, on an Air Force base, they may regulate which airplanes are allowed. Now, let's look at the last part of Article 1, Section 8, next to last clause. Quote, "and to exercise like authority over all places purchased by the consent of the legislature of the state in which the same shall be, for the erection of forts, magazines, arsenals, dockyards, and other needful buildings." Close quote. Notice that when the states sell land to the federal government, there is a condition. It can only be for a specified use. Also notice there is no permission to lease, only to purchase. No other permission is given. Thus, the federal government may not own land for any other purpose. Not to be used as a park, let that one soak in, not to protect an endangered species, not for grazing, or any other purpose. If the states agree to sell this land to the federal government, it can be only for the stated purposes that are constitutionally authorized. Now to the second provision allowing the federal government broader powers. Article 4 grants Congress power to dispose of and make all needful rules and regulations respecting the territory or other property belonging to the United States. This one is very simple. As these territories became states, Congress's powers under this article were terminated. The more we get into this subject, the more we understand how unique our Constitution really is compared to other countries whose Constitution, if they have one, was not designed solely to protect their citizens' natural rights by limiting the government to a list of the only subjects they can address. Next, we will briefly go over the 3 most abused clauses in the Constitution and tell you why they do not mean what some legislators, judges, and others say they mean. Those would be the general welfare, the commerce, and the necessary and proper clauses. When Congress wants to regulate a subject that is beyond their authority to address, they have to pervert the original intention of it. Let's take up three most abused clauses in the Constitution, which have been used by Congress and the courts to regulate subjects on which the Constitution gives them no authority to address. They are the General Welfare Clause, the Interstate Commerce Clause, the Necessary and Proper Clause. First is the General Welfare Clause. CNSnews.com posted an article some years ago. It was titled, "Hoyer Says Constitution's General Welfare Clause Empowers Congress to Order Americans to Buy Health Insurance." In this article, U.S. Representative Steny Hoyer said Congress had what he said was broad authority to force Americans to purchase health insurance, so long as it was trying to promote the general welfare. Does Steny Hoyer not know that this view was thoroughly examined and soundly rejected by our founders? Let's look at the so-called General Welfare Clause, Article 1, Section 8, the first clause. It says, quote, "The Congress shall have the power to lay and collect taxes, duties, imposts, and excises, to pay the debts, and provide for the common defense and general welfare of the United States." Close quote. Does that give Congress power to pass any law on any subject as long as it is for the general welfare of the United States? No, it does not, and we can prove it. James Madison addresses this clause in Federalist Paper number 41, among several others. Just a short word here about the Federalist Papers. Initially, the Old English is hard to read, but the more you read, the easier they are to understand. A side benefit is that the reader gains a completely new respect for the knowledge of the founders. However, since we are limited in this venue by time, we will simply paraphrase what the founders had to say on this subject. During the discussions at the ratifying convention, some members were reluctant to sign on and raised several objections showing how the document might be vulnerable by the general use of certain clauses. These continuing objections frustrated Madison. See if you can feel Madison's frustration in Federalist number 41 with regard to members referring to the General Welfare Clause. He says that those who oppose ratification are stooping to a new low of behavior when they say that the General Welfare Clause gives the federal government an unlimited authority to tax citizens in order to fund an unlimited array of matters. Madison, in fact, labeled that line of thinking as a misconstruction. This was his patient side. Later in the same paragraph, he explains that if there had not been a list to begin with, those who say the clause gives unlimited legislative and taxing powers might have a point, but they did provide a specific list. He continues to say, sarcastically, that the phrase must be extraordinary if it includes the power to destroy the power of the press, trial by jury, inheritances, and other such rights. In other words, he said it's pretty much a stretch. At this point, the reader can sort of feel his blood pressure starting to rise the more he wrote. Later in the same paragraph, the reader might imagine Madison late at night by lamplight, working to find a way to answer the skeptics as nicely as possible. So he asked the rhetorical question of how anyone can interpret this clause as general legislative permission to make laws on any subject when a specific list was provided. Finally, worked up, he labeled the idea to be an absurdity. Once you get the hang of reading the Federalist Papers, it really is fun, especially when you can use a little imagination and put yourself in their shoes at the time. So much for the framers' ideas on using the General Welfare Clause as authority to pass any legislation. But Congress has continued to use the clause because we, in the past, were not educated on the founders' words in the Federalist Papers and did not know the difference, and the courts are willing to go along with it as well. All that is changing, slowly, as more and more people take an interest and get involved. What you are learning today was common knowledge to the ordinary citizen back in the early 1800s. We have listed only one of the papers on this subject, but Federalist Papers number 14, 27, 39, 41, 45, and 83 all either directly or indirectly address the meaning of this clause. So you see there is ample evidence we have been misled for a long time. Now we move on to the Interstate Commerce Clause and its perversion. Bill O'Reilly of Fox News recently asked attorneys Megyn Kelly and Liz Weil whether Congress has authority under the Constitution to require us to buy health insurance. Weil said Congress has the power under the Interstate Commerce Clause, but Kelly said it would take days and weeks of research to answer the question. Let's see if we can walk through this question to the answer in 5 minutes. Article 1, Section 8, Clause 3 says in part, quote, "The Congress shall have power to regulate commerce with foreign nations and among the several states and with the Indian tribes," close quote. Hamilton and Madison in the Federalist Papers addressed that very idea and put it to rest using papers number 22, 42, 44, and 56. Again, let us say that due to time constraints, we are going over each of these points fairly quickly. The overall idea is to expose everyone to how the federal government has gotten away from the original intentions of the founders. Was this clause intended to give the federal government the authority to regulate any subject, any object that crossed state lines? Again, let's refer to the founders' own words. These Federalist Papers prove that the clause was to prohibit the states from imposing tolls and tariffs on articles passing through the various states. The founders saw this as a hindrance to free market forces, so this clause was intended to enable the free flow of goods as products move through the states without added taxes, thus improving the economy. As an example of the court's willingness to declare some laws constitutional based on this clause, consider the 1942 case of Wickard versus Filburn. We will not get into it deeply, but you will be shocked. It affected a farmer and his right to grow his own crops on his own land for his own consumption. Here is a good parallel explanation of it. See if you can make sense of it. If you cannot, then you can understand just how far courts will go to collude with legislators to let them regulate any subject they want. In essence, that opinion by the Supreme Court says, if you have tomato plants in your backyard for use in your own kitchen, you are affecting interstate commerce and are subject to regulation by Congress. The court's reasoning is this: if you were not growing tomatoes in your backyard, you would buy them at the market. If you were buying them from the market, some of what you bought might be coming from another state. So, by not buying them at the market, you are affecting interstate commerce because you did not buy something you otherwise would have bought at the market. Follow that? Now, when you hear a legislator or judge speak about constitutional authority to regulate a product or service simply because it crosses state lines, you can show them Federalist Papers 22, 42, 44, and 56, proving you did your homework and they did not. Next is the third in the series of abused clauses, the Necessary and Proper Clause. Note it's also known as the Elastic or Sweeping Clause. So, does the Necessary and Proper Clause in Article 1, Section 8, last clause, allow Congress to make any laws on any subject which Congress thinks are necessary and proper? No, it does not. It says, quote, "to make all laws which shall be necessary and proper for carrying into execution the foregoing powers, and all other powers vested by this Constitution in the government of the United States, or in any department or officer thereof," close quote. Note the use of the word foregoing. This clause permits the execution of only the powers declared and granted throughout the Constitution. Hamilton and Madison addressed that particular clause in Federalist Papers number 33, 39, and 44. The following short video was included here as Mr. Keyes gives an excellent presentation on the concept of enumerated powers, even though the interview was about the separation of church and state.
Actually, if you look at the Constitution of the United States says nothing about separation of church and state.
Absolutely not.
The First Amendment, which they always cite, the Establishment Clause, actually says Congress shall make no law respecting an establishment of religion. When you think it through, the real implication of that phrase also, though, is not to prohibit religious establishment. Some people argue that. No. What it says is Congress shall make no law respecting, not prohibiting, but respecting an establishment of religion. What does that mean? Well, respecting means concerning, on the subject of, with regard to, dealing with. So it means Congress shall make no law that has anything whatsoever to do with religious establishment. Well, my friends, if it can't address the issue at all, that means it can't say yes to religious establishment, and it also can't say no. It can't interfere with anything that's done on this subject. So you'll ask me, okay, Alan, who can address it? Well, the Constitution's also clear about this. In the 10th Amendment, it says that any power that's not given to the United States government by the Constitution or explicitly prohibited by the U.S. Constitution to the states is reserved to the states respectively and to the people. That means that the power that was explicitly withheld from the federal government, the power to deal with the issue of religious establishment, and remember, that means all these issues that have to do with the relation between church and state, how you acknowledge God, whether you acknowledge God, what can be done, prayer in schools, display of monuments, all the whole range of issues that have to do with that subject, right? The federal government has no lawful authority to address those issues at all whatsoever.